A company launches a new AI-driven customer analytics system across Europe. It collects user behavior data, transfers it to cloud servers outside the EU, and shares insights with third-party partners. No one is asking whether this is technically possible. The real question is this legally allowed under EU privacy law? That's exactly the kind of thinking the IAPP Certified Information Privacy Professional Europe, CIPP-E, exam is designed to test. This certification validates your understanding of European data protection law, including the General Data Protection Regulation, GDPR, privacy principles, lawful processing, international data transfers, and enforcement mechanisms under EU frameworks. In this video, we'll go through practice questions based on real privacy scenarios, where you must apply legal reasoning, not just definitions. Let's think like a privacy professional. Question number 1, startup company Magical is developing an AI system that will be part of a medical device that detects skin cancer. To take measures against potential bias in its AI system, the IT team decides to collect data about users' ethnic origin, nationality, and gender. Which would be the most appropriate legal basis for this processing under GDPR, Article 9, processing of special categories of personal data? A, processing necessary for scientific or statistical purposes. B, processing necessary for reasons of substantial public interest. C, processing necessary for purposes of preventive or occupational medicine. D, processing necessary for the defense of legal claims in potential negligence cases. Correct answer, C, processing necessary for purposes of preventive or occupational medicine. Explanation C is correct because GDPR Article 9 to 2H specifically allows processing of special category data when it is necessary for medical diagnosis, preventive care, or treatment. An AI system used to detect skin cancer clearly falls under preventive medicine, so this legal basis directly applies. Why others are incorrect? A, scientific research can apply, but it usually requires strict safeguards like anonymization and is less direct for clinical diagnosis use cases. B, substantial public interest is broader and not as specifically aligned as medical diagnosis provisions. D, legal claims is irrelevant because the processing is not related to litigation or legal defense. So Article 9(2)H is the most precise and appropriate justification in this scenario. Question number 2. What monitoring may lawfully be performed within the scope of Gentle Hedgehog's business? A, everything offered by Sauron Eyes software in relation to activity by sales team contractors. B, everything offered by Sauron Eyes software, assuming employees provide daily consent to the monitoring. C, only emails, website browsing history, and camera for internal video calls conducted in a non-secure environment. D, only emails, website browsing history, and camera for internal video calls that are expressly marked as monitored. Correct answer, D, only emails, website browsing history, and camera for internal video calls that are expressly marked as monitored. Explanation. The correct answer is D, because GDPR requires employee monitoring to be transparent, necessary, and justified. Employers must clearly inform employees about what is being monitored and why. Monitoring activities like emails or browsing are allowed only if they serve a legitimate purpose. Employee consent is usually invalid due to the power imbalance, so B is incorrect. Options A and C fail because monitoring must always follow proportionality, regardless of role or location. Therefore, only clearly communicated and justified monitoring complies with GDPR rules. Question number 3. The Merla HB Club should have carried out a DPIA before the installation of the new access system, and at what other time? A, after the complaint of the supporter. B, periodically when new risks were foreseen. C, at the end of every match of the season. D, after the AEPD notification of the investigation. Correct answer, B, periodically when new risks were foreseen. Explanation. The correct answer is B because a DPIA under GDPR Article 35 is an ongoing process, not a one-time task. Organizations must review and update DPIAs whenever new risks or changes in processing occur. This ensures continuous protection of individuals' rights and compliance with GDPR. Option A is incorrect because DPIAs are proactive, not done after complaints. Options C and D are wrong as DPIAs are not tied to events or triggered by regulators. Therefore, DPIAs should be conducted periodically when risk levels change. Question number 4. Through a combination of hardware failure and human error, the decryption key for a bank's customer account transaction database has been lost. An investigation has determined that this was not the result of hacking or malfeasance, simply an unfortunate combination of circumstances. Which of the following accurately indicates the nature of this incident? A, a data breach has not occurred because the loss was not the result of hacking. B, A data breach has not occurred because no data was exposed to any unauthorized individual. C. A data breach has occurred because the loss of the key has resulted in the data no longer being accessible. D. A data breach has occurred because the loss of the key has resulted in the loss of confidentiality or integrity of the data. Correct answer, D. A data breach has occurred because the loss of the key has resulted in the loss of confidentiality or integrity of the data. Explanation. The correct answer is D because under GDPR Article 4.12, a breach includes loss of access, integrity, or confidentiality of personal data. Losing the encryption key makes the data inaccessible, which means a loss of availability. Availability is a key security principle under GDPR Article 32, so its loss qualifies as a breach. Even without hacking or unauthorized access, GDPR still considers this a data breach. Options A and B are incorrect because breaches are not limited to cyber attacks or disclosure only. Therefore, loss of the decryption key clearly meets GDPR breach criteria. Question number 5. Once an organization has conducted an internal investigation to determine the scope of a ransomware attack, what is the appropriate next step in the process? A. Assess the risks associated with the breach and, if necessary, notify affected individuals and regulatory bodies within the relevant timeframes. B. Notify law enforcement and consult with legal counsel to understand the implications of the breach and the notification requirements. C. Inform all customers and the public via social media platforms to ensure rapid dissemination of relevant information. D. Wait for law enforcement to provide guidance on notification procedures before taking any further action. Correct answer, A. Assess the risks associated with the breach and, if necessary, notify affected individuals and regulatory bodies within the relevant timeframes. Explanation. The correct answer is A, because under GDPR Article 33 and GDPR Article 34, the first step after an internal investigation is a risk assessment. Organizations must evaluate the impact on individuals' rights and freedoms. If risk is identified, the DPA must be notified within 72 hours, and high-risk cases require informing affected individuals. Option B is incorrect because law enforcement involvement is not the first GDPR requirement. Options C and D are wrong since GDPR does not allow delays or informal public announcements. Therefore, assessing risk and then notifying relevant parties is the correct next step. Passing the CIPP/E exam is not about memorizing articles. It's about understanding how European privacy law applies in real-world business situations. Practicing scenario-based questions like these helps you. Interpret GDPR requirements in context. Identify compliance risks in data processing flows. Make correct decisions under legal constraints. If you want more CIPP/E practice questions based on real GDPR scenarios, check the link in the description for additional resources available on CertBoosters. Subscribe for more privacy, governance, and compliance certification practice sessions. Thanks for watching, and remember, in privacy law, the right answer is always the one that protects the data subject's rights first.